Welcome to Mandy. We'll be doing a hearing that is not the Louisiana Board of Paroles. This is Judge Aaron Garthier's courtroom, and this was shared with me by Richard, so thank you. We're about to watch the hearing of a cockroach who, that is what we title people who prey on our children. So we are going to watch the sentencing hearing for this man.
All right, we're back on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we have up next a sentencing in both state of Michigan versus Thomas Charbonneau, file 22-6380FH. Counsel, you want to state your appearance, please?
Melissa Goodrich, Wayne County Prosecutor.
William Key on behalf of Thomas John Charbonneau, seated on my right.
Okay, Mr. Keo, we're here for sentencing on a charge of breaking and entering, habitual second, 15-year maximum. And you had a chance to review the report and recommendations with your client.
I have, Your Honor, we have no objections or corrections to make to the report.
And the advisory scoring is at 5 to 28 months. Any scoring challenges?
No, Your Honor.
Mr. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
And Mr. Keo, anything you'd like to say on behalf of your client?
Yes, Your Honor. I've had an opportunity to get to know Mr. Charbonneau quite well over the past probably 10, 15 years. And I know that Thomas had, as illustrated in the PSI, numerous problems with alcohol. I think this is another indication that alcohol has impacted his life in a very negative way. And my hope is that at some point he's able to get control of that issue. I know that there's been a statement here in the PSI that essentially there are no other tools available to him to address his issue with alcohol and alcoholism. I don't necessarily believe that. I think, to my knowledge, I don't think he's ever been in an inpatient rehab facility, and I think that's probably something that's long overdue for him. In regards to his criminal history, I understand there are a number of things here that are of concern to the court. I would emphasize, though, on his behalf that many of the scorable misdemeanors are quite old, probably in excess of 15 years old. In regards to misdemeanor or felony cases, he has 2 prior felonies, one of which was 10 years old, and the other one was, I believe, before the year 2000. So his record, at least in the last 10 years, has been relatively uneventful, although it's usually based on alcohol or alcohol problems. So for that reason, we do agree that a local sanction would be appropriate because I think this is an alcohol-related offense. I don't think he has any sinister criminal intent when he does the things that he does. I think most of the time he does the things that he does is because he's been drinking excessively. I think a long term of incarceration locally and a term of probation with the ability to go to inpatient rehabilitation would be our request to this court. I thank the court.
Thank you, Mr. Keo. Mr. Charbonneau, it's not required that you would make a statement and is allowed. Is there anything you wish to say or no? Mr. Rich, any recommendations from the people?
Your Honor, if the court would allow the victim's father, Mr. Wheeler, to speak.
Certainly. Mr. Wheeler, if you want to come on up to the podium. Go ahead and let me know anything you want me to know before I decide Mr. Charbonneau's sentence.
This incident really did not help matters. We're already going through a similar situation. We finally get our daughter to where she's interacting with us again. And then now we're back to the same thing. We're just getting better lately, but it took a lot of months for us to get to where we were. And then to be spied on again, the same situation, especially after you were supposed to have been gone, and so we have to run home and to look in my daughter's room, not to mention my 5-year-old standing right there. I can't get him to answer the door. We got to be standing there with him. Alyssa's still a little distant, she's still going through all her stuff. This did not by any means help us at all. It's how do you make your children believe that you can protect them when people are doing stuff like this. I'm no angel, but you know, there's a certain boundary that doesn't cross, and this is one of them. It's a real serious situation. I mean, considering the fact that if I hadn't come around the corner, what would have happened? You know, what would have happened in 30 more seconds or a minute if I wouldn't have caught the door that was being shut and closed multiple times, you know? Who knows how far we even went? And that's the crazy part is, I don't know, it's fearsome to say that, I mean, how many other people are gonna happen to? You know, if I gotta stand here and say that what it's done to us, it's pretty much destroyed us. My daughter is not been right. You know, in counseling, as much interaction she can get from us. I mean, it's pretty much all we can do. We got to pull her out of school multiple times because break down stuff. I don't know, and you can't predict it just hits. You might be fine for 2 months, you might be fine for a week, you know, it just goes through these phases. So, and I think it has a lot to do with this didn't how it matters. It's just, I think it's an unacceptable thing.
Thank you, Mr. Wheeler. Mr. Rich?
Thank you, Honor. The defendant is 58 years old. He does have a significant criminal history with 2 prior felonies and 26 misdemeanors. He has a high school diploma. He's unemployed with sporadic work history. He reports substance abuse issues since he was 5 years old. He's already served 139 days of jail. The guidelines are 5 to 28 for plea agreements so that he'd be sentenced within the guidelines. The recommendation is 12 months of jail with no probation. I'm asking the court to look at the defendant's history. I think there's a pattern of behavior here that's concerning. On August 9th of 2013, as reflected in the PSI, a mother awoke to a man inside her residence who was the defendant. He had picked up her 4-year-old child and moved him from the couch and placed him on top of the coffee table. She did not know him. Also, during that same investigation, another woman reported the defendant had been on her porch looking in the window. On May 6th of 2021, one reported walking down her hallway and seeing a man climbing halfway through her bedroom window. He was waist up inside. When she yelled, "What are you doing?" he just smiled at her. Again, the defendant engaged in similar activity. Now on April 17th of 2022, defendant is found in a house uninvited again with a child. It was another child who found him. The older brother saw defendant talking to his younger sister, stroking her head while defendant was holding his crotch area. The defendant has previously served 14 jail sentences. 3 times he has served the recommended 1 year here today. He also has served 9 terms of probation. 2 of those terms were unsuccessful. The defendant has a criminal history that spans from 1989 to 2022. My recommendation is for high end of the guidelines at 28 months. Thank you.
Thank you, Mr. Charbonneau, if you'd stand for the court sentence, please. Mr. Charbonneau, a lot of your criminal history is, as the attorney said, alcohol related. You know, a lot of those misdemeanors are a long time ago, and a lot of them are not not of the type of offense that, you know, gets much attention in a circuit courtroom. But there's a couple of prior ones that are really disturbing that prosecutor highlighted. So in this case, you're convicted of breaking and entering, breaking and entering, going in somebody's home, and looking at their kid. And you've got a conviction for the same darn thing 10 years ago. And in the interim, just a couple of years ago, you're convicted for attempted disorderly person window peeping. And while you're on probation for that one 10 years ago, you're window peeping. So there's a real creepy pattern here, Mr. Charbonneau. You getting drunk and then poking around people's homes and going in people's homes and looking at kids. What do you think all the rest of us think about that? You know the conclusion we're all drawing from that. So, there's no evidence that you've ever harmed a child or, sexually predated on a child in any fashion. But my goodness, this is not the kind of behavior that civilized people tolerate. You're lucky in all these incidences, you didn't encounter an armed homeowner. They've blown you away. And they would have never gone to jail for it, because it would have been totally justified. You don't get to look around people's houses and go in people's houses and creep around kids. You don't get to do that. And you've been to jail for a year 3 times before.
Wasn't that way.
You're 50, well, it was that. You're 58 years old, you've never been to prison, we're gonna change that today. I'm gonna commit you to the Michigan Department of Corrections at the top end of the guidelines for not less than 28 months, nor more than 15 years, exercising my discretion under the habitual statute to increase the statutory maximum. For $68 in state costs, $130 in crime victims assessment, and $350 in court costs to assess. I am going to give you credit for 139 days you have previously served. This is a sentence within the advisory guidelines range as pursuant to the sentence agreement in this matter. So Mr. Charbonneau, if you wish, you can file an application for leave to appeal to the Court of Appeals. If you want me to appoint an attorney, you have to ask me within 42 days. So we're going to give you a copy of that appeal paperwork. 1 copy is for you to initial and give back to us. The other one's for you to fill out if you want to take it. So what did you say?
Tell the prosecutor liar.
All right, bring it back in.
Called what's his name up here, liar.
He called the prosecutor a liar. What he was talking to the first time, I think, was the woman.
No. Not unless you want to join them. Not unless you want to join them. No, not unless you want to join them.
So the first person he spoke to was that woman. Maybe he said, call me or I'll call you or something. And then the second thing he said was, you're a liar. I can't wait to see what the judge is going to do here. And then we'll unpack this case. I wonder what the process is, why he doesn't just come back in.
Charbonneau, you stand at the podium there.
Maybe they had to handcuff him.
Mr. Charbonneau, you are in contempt of court, direct contempt of court for calling either the prosecutor or the victim's father a liar. I'm not sure which. You are in contempt of court. If you want to compound it, go ahead and continue.
Sorry.
I'm going to assess a $500 fine for that contempt, and I am going to order that that be part of the prison remittance order to come out of your prison. All right, now you can go back. All right, next up, we've got People versus Matthew Palace.
Okay, let's unpack that. I love it. The $500. That's not a small thing. It's coming out of his prison. So, it's gonna come out of his precious commissary money or whatever he earns in prison, and that's a lot of money. It's gonna take him a long time to pay that back, and money that he won't have in commissary. So that is no slap on the wrist. That is actually that's actually going to be haunting him for quite some time. And what I have to say is, I am so happy to see a judge give the maximum sentence. We have seen so many times in the parole hearings sentences that are just unimaginable. That you're left not just shaking your head, but banging your head against the wall, screaming, "How is it possible? How is it possible?" When you see a father with 10 other children and grandchildren who's abusing his own 3-year-old and getting a 7-year sentence and then parole after 3. This man has been just a waste of space, what we call a cockroach. No excuse for being on this earth. The judge had said, what would have happened if a homeowner had a gun? You're lucky he didn't have a gun. Well, no one's lucky he didn't have a gun. A homeowner with a gun should have wiped this scum off the face of the earth a long time ago, and we would all be better for it. The prosecutor recommended 3 years. The minimum was a year. The prosecutor recommended 28 months. And I know the prosecutor does it. They want to avoid a trial. Trials are expensive. So, kick the ball down the road, save everyone money. Don't make the children have to get up in court, and that I won't pass judgment on, because if it appears that the little girl had already been through something, and this is like a second time, and to get up and to have the 5-year-old brother get up in court. But this is what happened. He sneaks into their house. He is caught rubbing the daughter's head while also rubbing his crotch. The 5-year-old brother sees it, and at that moment, Dad comes into the house and sees this man doing that. How he had the self-control to not destroy that man on the spot, and he would have been able to by law, is he must have just been in shock. Must have not known what was going on. It was his attorney framed it. The last 10 years have been relatively uneventful for my clients. I've known him for a long time. This is, he's had alcohol offenses, and this is just another alcohol offense. There's no proof that he had any bad intentions. Really? He went into a home, was touching a little girl while touching himself. What kind of intentions is that? He tries to pass it off as an alcohol-related offense. He just walked into the wrong home and there was a little girl there. What's wrong with that? I know that attorneys have to do their jobs, but man, I don't know how you look yourself in the mirror to have to defend pedophiles. I get that what I just said is a loaded statement. We need a world where attorneys defend everyone, but I just don't know how they do it. And I really commend Dad for getting up there and speaking. And what he said was, what would have happened? What would have happened if I had come back later? What would have happened if I had come back 30 seconds later, 10 minutes later? That has got to be keeping him awake. Has PTSD, trauma. I can't imagine the trauma just from those nightmares of what if I had come back later. His daughter and their son seem traumatized from this experience. His son, he said, won't answer the door unless his father's standing next to him. This is trauma that these kids have experienced by in their home having a complete stranger. This wasn't his first offense. This wasn't his first offense. The prosecutor listed that it was just 2021 that was it March of 2021 that he was in the bedroom of in another house where there was a child? And then April 17th of 2022, he was caught climbing through a window? This guy is like these are the times he's caught. Ten years ago, he had the same offense about where he snuck into a house. He picked up a 4-year-old and put the 4-year-old on a kitchen counter. And this wasn't his house. No one knew. This man is the worst kind of predator that exists. It's a cockroach. He preys on little children. He's obsessed with little children. It's all he can think about. It's all he dreams about. It's his obsession. And for his lifetime, he's 58 years old. He's got a record that goes back, what is it? He said since 1989? 2 felony arrests. Was it 28 misdemeanors or 50? More than that. Which means that they could have been felonies. They were dropped down. We know that. He's so comfortable in handcuffs. And he's never spent time in prison, only jail. Because judge after judge after judge was, for some reason, giving this creep, this monster, this predator leniency. And why? Tell me why. If he was caught smoking pot, he would have gotten, in 1989, could have been 10-year sentence easy. Maybe even 25 if he had enough of it. Sickening when you think of it. I really enjoyed listening to what the judge had to say. He said, you don't get to creep around people's houses and touch kids. And this cockroach says, I wasn't like that. What were you doing inside the house, you freak? What were you doing inside the house, touching a strange girl, a little girl, a stranger? What are you doing? The judge says, what are we supposed to think? And then I do disagree with one thing the judge said, which was, there's no proof that you have ever done anything or hurt any child. And I disagree. He's touching her head while touching himself. We have a 5-year-old as a witness. No 5-year-old makes that up. That's proof enough for me. He has a track record of doing the same thing 10 years ago. So he's probably going to have a first chance of parole after 3 years. We'll love to watch that hearing. He's 58. He should spend the next 15. He's got to just spend the whole thing locked up. Then he calls the prosecutor or the father a liar. Liar. Really? Everyone must be lying, huh? You're not just creeping in people's houses and touching kids. With that, I'll let you go.